A father and his adult son have been arrested in connection with the death of a 2-year-old boy. They told police the toddler fell down the stairs, but the autopsy didn't back that up. Instead, it was the result of an acute incident, meaning whatever happened was sudden and not the result of a fall. Police say the two tried to take off after the boy's death, but law enforcement eventually caught up with them. Now, both men are behind bars. Thanks for joining us. I'm Kennedi Walker, and I'll walk you through the details. You're watching Law and Crime. For this story, we go to Green Bay, Wisconsin. There, a little boy who loved laughing and dancing is now being remembered instead of celebrated. 2-year-old Leo Escalante was known for lighting up every room, smiling, singing, and stealing hearts. His family described him as joyful and full of energy. And now, the family is left holding on to memories and mourning what could have been.
My nephew doesn't get to try to run on this earth again.
Police are naming James VanderLeest and his father, David, as the ones responsible. Both are expected to be charged in connection to Leo's death. The two appeared before a judge after being arrested.
A lot of this is lies.
Here's what we know. On June 22nd, around 9:15, police were called regarding a 2-year-old boy with serious injuries. That boy was Leo. He was flown to Children's Hospital where doctors worked to save him. But just 2 days later, Leo was gone. According to WLUK, investigators say both men initially claimed David was the one watching Leo that morning. But the deputy district attorney says it was actually James caring for the toddler when everything happened. Prosecutors say James claimed Leo fell down the stairs, but the evidence was not adding up.
Because it's alleged to be an acute incident that would have happened instantaneously, could only have happened at the hands of the person that would have had the child with them, and that is James VanderLeest.
James is reportedly the ex-boyfriend of Leo's mother and not his biological father. It's still unclear why the 2-year-old was in his care that day. James reportedly has several open criminal cases, including charges involving domestic violence, one of them linked directly to Leo's mother. And according to prosecutors, James pressured her to cover for him.
James actually told her to say that his dad was the one who was there with the child at the time.
After Leo's death, police say the VanderLeests were found hiding at a relative's cabin and were eventually caught with help from a SWAT team. According to police, David insisted that he wasn't running, but trying to protect his son.
My child was very suicidal. I went and found him to make sure I didn't find him hanging from a tree.
But prosecutors are not buying it, calling their disappearance obstructive and dangerous.
There was 20 to 25 minutes that David and James stayed in this house barricading themselves and wasn't coming out until they did a flash bomb.
Now, James VanderLeest is facing a recommended charge of first-degree reckless homicide. His father, David, could be charged with harboring or aiding a felon. And here to break down this story with me is Josh Corman, a criminal defense attorney. Josh, thank you so much for coming on today.
Thanks for having me.
So let's start with James. What does first-degree reckless homicide actually mean in a case like this? And is that the same as murder?
So I think in Wisconsin, essentially it is, when we think of murder, we think of intentional murder, like someone deliberated or they premeditated or planned it out. I think under this statute in Wisconsin, it is for someone to have recklessly caused the death of another person. And I think what elevates it to something higher in Wisconsin is that there is a clause in the statute that said there was an utter disregard for human life. So no one is saying that this is something that happened on purpose, but for whatever it was that they're alleging is how this child died, that James recklessly caused this, which basically just means it was a conscious disregard for the life of another person that resulted in a death. So it is a Class B felony in Wisconsin, which this charge would carry up to 60 years in prison.
60 years in prison. Wow. And then any mandatory minimums with that?
So that's a great question. And I guess it depends on how the case ended up playing out and how the judge sentenced it. I just know that that's what it is, up to 60 years is kind of how it's phrased for the sentencing statute in Wisconsin.
From a legal standpoint, what will prosecutors need to absolutely prove in order to secure a conviction here?
Well, they're going to have to prove how the child died. an autopsy or the medical proof is obviously going to be the most important thing in this case, to try to prove what those injuries were and how those injuries could have occurred. It's my understanding that I think there was a statement made early on about the child falling from the stairs or fell down the stairs or something like that. And that was against I guess, the medical testimony that was given to the police during the investigation. And so that's something that the prosecutor is going to have to prove, is that this person, whoever is responsible, recklessly caused the death, but then how exactly it was that the child died, and that the child could not have died from the result of just an accidental fall down the stairs.
And with that, I mean, just how important will expert testimony be when you're trying to prove something like that? Like, who usually takes the stand?
Right. So the medical examiner is certainly going to be testifying. He's going to testify about the autopsy results and what those findings were. You're also going to have someone testify from the hospital, whichever hospital treated the child and did the x-rays or MRIs or CT scans or whatever they did. And I would imagine probably an ambulance driver, whoever it was that originally came in contact with the child, and whoever else was there. I'm not exactly sure how law enforcement first came in contact or how the child was taken to get medical help, but all of those people would end up testifying at a trial. And I think the most important witnesses of that would probably be the medical examiner and the doctors that treated the child at the hospital, to explain what all these injuries were. And just kind of reading between the lines, I think that there would be testimony for much more serious injuries than you would expect from a fall. Usually those are going to be like internal injuries, like maybe from a lacerated liver or spleen or something like that, that would not be consistent with falling down the stairs, but would be consistent with kind of much more brutal trauma, like punches or kicks to the abdomen or a head or something like that.
That is horrible. Well, is the fact that James allegedly lied about who was watching the 2-year-old going to hurt his case?
I think anytime you make a statement, and anything that you say should be shown that that is not correct, or that you have made inconsistent statements, or you've changed your story, those are certainly going to be very harmful in that case when it comes to trial, because those are all going to be things that the prosecutor is going to bring up. And the argument is always, well, the truth doesn't change, but if you keep changing your story, then certainly that goes to your credibility in front of the jury, or how the jury is going to evaluate the case. As with any kind of flight. In this case, I think there was some evidence also that he had taken off. He had gone to some cabin in the woods, and there was a barricade situation. Those are all things that I think would be argued to a jury, that evidence of flight is a consciousness of guilt. And so any kind of inconsistent statement or flight, those are all things that are not only going to affect credibility, but they're going to be argued to a jury if that's something that a guilty person does.
Right. And we'll touch on that in a moment. But also, before that, reports say that, or prosecutors say that James allegedly told Leo's mother to lie and say that his father, David, was the one who was watching the toddler when he, again, as he said, it fell down the stairs. Does that open James up to additional charges, like maybe even witness tampering?
It probably is not going to open James up to more charges. And obviously the charge that he has right now is about as serious as it gets. So even if that did open up to more charges, those would be, lesser charges, and probably wouldn't make much of a difference in the end. But that is evidence that would certainly come out. Again, him trying to hide the facts, or trying to get a witness to say something else, or again, saying something that's not consistent with the other evidence that may come out, is going to be showed and argued as consciousness of guilt to the jury.
Let's talk about the father now, David, or James's father, David. He's not charged with hurting Leo, but he is accused of aiding a felon. How serious is that?
So in Wisconsin, it is, I guess it can be different levels of felony depending on what it was that you were aiding and abetting. For this charge, I assume it's a Class G felony, which carries up to 10 years in prison under Wisconsin law. It could be less if the underlying felony that you're aiding and abetting is a lesser charge. But for the serious charges, like what his son is charged with, it would make him eligible for a Class G felony, which again would be up to 10 years.
He's claiming that he was just trying to help his son and not hide from police. Does intent matter in a charge like this?
It will certainly matter for his reasoning. I think the argument was that he was worried about his son. His son was suicidal, and he basically went to his son to try to save his son's life, or he was worried that his son was going to kill himself or something. That's one of those kind of double-edged swords in this case, though, because his son being worried about, I guess, to the extent that he would kill himself or something is going to be another argument the prosecutor could make, that he's guilty of this and knew he was guilty, and that's why he was going to take his own life. For his dad's case, though, assuming that a jury finds that credible or a prosecutor finds that credible, that certainly, I think, would affect whether either a jury would convict him of that, or a prosecutor would go forward with those charges, because that does seem, in my opinion, to be kind of a good excuse that you went to go help your son. I think anybody in that situation would want to try to help their kids. Certainly if they felt like their child was going to commit suicide. Now, whether that's true or not, I don't know, or whether that is kind of, I guess, contracted with the barricade situation that it sounds like then that they got in with the police, that may underscore or undercut any argument that he's making about that wasn't his intent. But that explanation on its face seems like a logical explanation, in my opinion.
Well, let's dive a little bit more into that SWAT situation that we're talking about. The SWAT team got involved. The prosecutor said that both men allegedly fled and the SWAT team had to come, and that's how they were able to get them out. How serious is that? And just how much worse is this situation now because of SWAT?
I'll be honest, in my opinion, I think SWAT sometimes makes the situation worse. I mean, I can understand why law enforcement would have to be very careful when they go out, when you have a violent felony or a serious felony. But again, this is a child abuse type case. In my experience, a lot of times SWAT going and getting involved in some of these arrests actually makes the situation substantially worse. I think people, get freaked out when all of a sudden you realize you're surrounded by, armored cars, or people with assault rifles out and sniper rifles and all kinds of stuff, and that makes the situation much worse. That being said, I can also understand from law enforcement perspective, they need to make sure they do their job and return home safely to their family every night, and they're going to take every precaution necessary. But again, barricade situations actually happen more regularly than I think we realize, where when SWAT arrives at a house, people react in a different way, because it is that, in my opinion, it's a very traumatic experience to have SWAT surrounding your house and flashbangs thrown off, or your door busted open when you're not ready or prepared for that. So a lot of times the SWAT situation, I think, makes situations much worse and ends much more dramatically than it ever needed to.
Right. Well, let's move on to just the James's criminal past. When someone has open cases, especially involving violence, can that history come into play at trial, or does it get blocked?
So most of the time, it's not going to be allowed in trial, although it may be allowed in sentencing. So the judge may be aware of it, and at sentencing, those are things that could come up to enhance how much time someone is potentially looking at. So, like, as an example, we said it could be up to 60 years. When we say up to, those are the kind of things that may enhance a sentence, that someone has a prior record, or there's evidence that they have been violent in the past. Otherwise, those things should stay out of the trial. Rule 404B is what kind of dictates that, what gets into what's called prior bad acts, or prior convictions, and whether that would be allowed or not. That's something that there probably would be a hearing before the trial for the prosecutor to present whatever evidence that they want the judge to allow, and the judge would have to make a decision prior to trial of what things that they would be allowed to bring in and not bring in. And there's all kinds of exceptions to that rule, whether it would go to motive, intent, or like I said, there's all kinds of exceptions. So that's those things get litigated very often, and those are the kind of things that often get reversed on appeal when evidence is allowed in by a judge that should not have been allowed in.
You have a lot of experience. If you're defending James, what arguments would you lean on to create doubt?
Well, certainly I would assume that his defense team is going to be talking to medical experts to try to get their opinions about the injuries, and how exactly it is that he says those injuries happened or could have happened. This very well could end up turning into one of those trials that's like a battle of the experts, where they're trying to explain how those injuries occurred, and that it could have happened by some accidental way, like falling down the stairs or something else like that. So I would assume that that's something that the defense is certainly going to be exploring and trying to figure out if that's going to be a viable defense at trial. But that seems like the first obvious defense in any kind of a child abuse case like this.
Do you think even bringing up like past trauma or medical conditions that the little boy may have, or do you think that that's going to be their best option solely just leave it up to a battle with the experts?
Well, it kind of also depends what the experts have to say, right? That's something you might be consulting with experts, and hopefully those experts have something that's helpful to you. But it could also be that the experts say, "Nope, I reviewed all the medical records. We concur, with the state's experts. We think the same thing, and that's not something that would be helpful at all." And if that's the case, then you may have to be exploring some other kind of a defense. And again, I don't know anything about the child, or like you said, if the child had other injuries prior to this, or had any kind of mental condition or behavioral issues, or whatever may have been in his background. But certainly those are all things that I think any defense attorney is going to consider and see what types of defenses would be viable.
Could the state try to flip one against the other, especially if there's fear of a weak case?
Yeah, I think that happens a lot whenever there's going to be co-defendants. I think everyone is always wondering, is the state going to make a deal with somebody? Is someone going to agree to cooperate? Certainly in a case like this, assuming that it is James that's responsible and not his dad or someone else, then it does make sense that they would try to, use his dad to cooperate and maybe testify. And it doesn't necessarily mean he's testifying against his son, but it may be he's testifying to the facts that he knows about, which probably would not help his son, but because he is looking at significantly lower charges. Although I think there's some mentions in the news that the prosecutor has threatened or has floated out there that the dad could be charged with more serious charges because he didn't seek treatment for the child or something like that. That would be a good plea bargaining chip for a prosecutor to be using to try to get the dad to cooperate in the end.
How do cases like this usually play out? I mean, you have a jury, some of them may be parents, they're hearing about this alleged abuse that occurred. Any fear that, there's some parent that just can't look past this and that they're tainted?
Sure, and that's the reason for voir dire or jury selection. Usually in a case like this, jury selection would probably last, at least a day or so, where all the potential people that had jury duty would be questioned about their own experiences, where you try to get a fair and impartial jury. And you're exactly right. Having parents on the jury can be a double-edged sword. Some parents probably can understand, and they understand there are accidents, kids fall down the stairs, there's all kinds of things that kids get into trouble that a parent isn't responsible for. But then also you have the sympathy factor of, a 2-year-old child who is dead, and somebody has to be held responsible for that. So jury selection in a case like this is going to be incredibly important to try to get a fair and impartial jury for both sides.
Given the fact that the child has died, do we expect his mother to take the stand?
I would assume so, and I would assume the mother probably has all kinds of information that would be relevant in the investigation. It's my understanding that James was not the father of the child, but was her ex-boyfriend, and I believe she's also an alleged victim in some of the charges that he had pending in court. So she certainly would have important information. Then it just becomes an issue of which part of that information would be admissible in court and what she could testify to and not testify to. It may not be that she could testify about any abuse towards herself, but there could be previous allegations of abuse towards her child that she would know about. And that type of evidence probably would be admissible, even though it'd be very, very damaging to James's case.
Is there a legal explanation for why the charges haven't been officially filed yet, or is that delay strategic?
I don't know that it's strategic. It could just be a timing. I think from when he was arrested, every state has kind of different rules of how long you can hold someone until charges have to be filed. Or if this is a situation where, there's multiple levels of court, they may just have a probable cause hearing at the very beginning, and then charges would either be indicted later on or filed by information or complaint. Since I don't practice in Wisconsin, I don't know exactly how they do their initial parts of the charges. But I think that's somewhat typical in any jurisdiction, though.
Could either of them take a plea deal, and what would that look like in a case involving a child's death?
Right. So the answer is yes. I think in every case, right, the overwhelming percentage of cases across the country end up in pleas as opposed to going to trial. And that's, the risk versus reward, certainly for a defendant, but then also for the prosecutors, depending on how strong their proof is or the experts or what's going to happen. Almost always there is going to be plea negotiations that happen in a case, and whether the two sides can come to an agreement or not is what remains to be seen. But in almost every case that I've ever been a part of, there is at least some type of plea negotiations or plea offer that would be made.
Any type of timeline that we're looking at here?
Again, in I guess Green Bay, where the case is, I'm not exactly sure how quickly their cases move through the docket, but in my experience, this is the kind of thing that would probably go on for at least a couple of years between the first part of the court process, getting indicted, getting into the trial court level, going through all the discovery levels, discovery phases, meeting with the experts. Oftentimes these cases go on for 2-3 years. So I would not expect anything quickly.
Wow. Well, very sad story here, and we're definitely keeping that mother in our thoughts. Josh, thank you so much for coming on today.
Thanks for having me.
James was issued a $2 million cash bond. David was issued a $100,000 cash bond. For Law and Crime, I'm Kennedi Walker.